the validity of the company's request to invalidate the utility solution patent number 774. Finally, the value of the documents related to the transaction provided by Hong Food and Company. For the first issue, according to Article 126 of the Intellectual Property Law, the Companies Act of Producing and Trading Aluminum sheet used to make rolling doors is an act of infringement of the exclusive patent protected under the GPHI patent number 774 of Hong Food and Aluminum Company. So because the company used this utility solution to gain business profits despite being reminded by Hong Food and Company. And as of 2010, the utility solution patent number 774 is still valid, and based on due to the above violation and based on the Article 199 of the Intellectual Property Law, the sanctions specified in Article 202 may be applied in this case. For the second issue, the act of producing and selling counterfeit goods by the company has affected the related interests of Hong Food and Company according to the provisions of the Intellectual Property Law, because Minh Yu Phong Company used the counterfeit products from the company due to the price of the products price was cheaper. Therefore, the act of infringing the intellectual property rights of the company has caused a loss of income and business opportunities of Hong Food and Company according to Article 204.8.1.8 of the Intellectual Property Law. For the third issue, the request to invalidate the utility solution number 774 of the company is invalid because the company had complained about this the validity of this patent before, which was not accepted because there was not enough evidence. Currently, the evidence provided by the company is not new evidence. And for the final issues, the Hong Food and Company determined the amount of damage based on the contract is 167 million and 345,000 VND due to the company's counterfeit products being cheaper than Hong Food and Company. Investors signed with the company. And second, documents relating to the parties' transaction provided by Hong Food and Company were not valuable as evident under the provisions of Article 11.81, 82.1, and 83 of the 2004 Civil Procedure Code. And finally, Hong Food and Company failed to provide the relevant witness testimony. And in conclusion, the Company's act of producing and selling and trading the aluminum shaped products used to make the rolling doors is an act of infringement of the utility solution patent number 774 protected by Hong Food and Company. And next will be the third case.
So for the case number 3, 1109, this case is about the a dispute between plaintiff who is UVN and defendant with the CUONG production and trading company. So in this case, the Sunlight dishwashing liquid products had a trademark registration certificate in industrial design patent number 13708 from the UVN. In UVN, in this case, sues that for allegedly infringe on industrial property right. UVN then requests the court to force Davihoom to temporarily stop productions, distribution, and use in trading of canvas dishwashing liquid bottle design and publicly apologize to survive. So the issues in here was that the CUONG company acts of using Sunlight bottle design, which was granted by the industrial design patent of the UVN, infringement of industrial design or not. If they were sanctioned applied here, what were they? So in this case, the rules here is Article 141.1, Article 126.1. Into article we decide whether UVN is really the licensee of Sunlight bottle design, and about the act of infringement of right to invention, industrial design, and layout design. For Article 5 and Article 100 and in Article 10.4 of Decree number 105/2006, the production and sale came back responsibly with products with the infringing part of the side of the Kuong company with the owner permissions is infringement of the protected border industrial design, which is violating the provision of law. The provision of the law on protection of intellectual property rights. So for the protecting right of industrial design for the Article 65.1 of the intellectual property law stipulate the novelty of industrial design as follows. For more specific in here is two industrial design are not considered significantly different if those two industrial only different in design features that are not easily recognizable, memorable, and cannot be used to distinguish the two industrial design as a whole. Therefore, in this case, the Kuong Productions in Trading Co. company has used a dishwashing liquid bottle design that is not so different from the UVN registered dishwashing liquid bottle design. So the act of infringement is according to Article 126.1. Regarding that there is a usage behavior and the industrial design does not differ typically from the design in the same or similar or related field of goods, so that the Kuong company illegally used the industrial design which belongs to the UVN without any permission for profit and distribution purpose as described in the article above. So in this case, the sanction for these violations is as the request of plaintiff, the court accepted the case number 44 2015, 26 May 2015 in the year 2015, including the portal of canvas that were restrained according to the decision to apply the temporary emergency June 1st, 2015 of the People Court of Ho Chi Minh City from September 29, 2015, and do not use this design in the future because the article also has changed its new designs. So moving on to the advanced case, which is the last case of our representation team is between Apple and Ericsson's. In this case, Apple is suing Ericsson for declaratory judgment on 7 patents, claiming they are essential to the long-term evolution for short LTE wireless communication standard. Apple seeks to declare these patents not essential to the LTE standard and that Apple products do not infringe on them. And Ericsson has filed motion to dismiss the case, but both have been denied. And the issues in this case is, first is, was Apple use of 7 patent infringement of patent rights of Ericsson or not? Secondly, did the 7 patent declared by Ericsson actually belong to the LTE standards, leading to that is Apple productions violating the Ericsson patent rights? And the third is, did the evidence presented by Ericsson support their own claims? For the Ericsson arguments is, Ericsson argued that the Apple complaint is insignificant compared to the larger dispute between the party and that the court lacks subject matter jurisdictions. Ericsson claimed that the controversy involved in its entirely portfolio of patents essential for the 2G, 3G, and 4G LTE standard, and that Apple would need to take a license to these patents. However, Ericsson relying on various cases did not support for its own position, so the court will need to determine whether the case is justiciable based on the specific circumstances. And for the Apple argument, he said Apple alleges that Ericsson holds several essential patents to the LTE standard, including the 7 patents in question, and accused Apple of infringing them. The court finds jurisdictional based on these facts and reject Ericsson's written argument. The Supreme Court rejection this reasonable apprehension to suit test in the Macmillan case inside as report. So in this case, in summary, the court rejected Ericsson's motion for forum non-convenience and the action does not fall within the scope of the forum selection clause in the license agreement in the NGA issue is insufficient to require dismissal or transfer of the entire actions. The court also determined that the cited case does not support Edison argument at all, and therefore dismissal under forum non-convenient doctrines is not justified. And that is the end of our presentation. If you have any questions, you can read those documents below.
So any questions so far? So I have a question concerning your case law. So the first case you mentioned about non-fact company, right? They can change the pattern. So then you determine what is an act of infringement in this case. How to determine an act of infringement? Which article and which action? Okay.
The non-fact, the infringement action here is non-fact company production, trading, and the product name SESTA Gold. That product, that act is violated the
Which act? What's the keywords? You write out on the table, on the board. The keyword. What's the key action of this? Because it's very important to determine which specific act. Okay? To conclude action of infringement. So can you write for me a verb? Let's explain an act of infringement. Which one? One keyword. One word. Yeah. If you can guesses. Produce a product. Both. Can anyone find that keyword? Which one? Yeah. You know that word? Which one? Nearly, that's approximately. A little bit. And that start with an I. First word, I. What's your name again? Nhi. Okay? You start with an I. Which word? And from that keyword you will find out which article we will use in this case. So in order to determine an act of infringement of patent, we use which article? Which one?
$126.
126. And what they say? Article 126. So anyone in this class found out this keyword? It's like a math. We do math, we do calculator. From this action, I will derive to another action, and therefore we add for 126.
Is that word is invented?
Nearly. It's not event. Non-fact company is not event.
Yeah.
Right?
They use the invention.
Close. We start with an I. How that? Specific is important. So that's keyword. Okay, you know how to do it. So actually, the company they import to chemical substance. Okay, and this act before reading the article, you write down article 124, right? 124. Let's say that. What is the meaning of using? Using does mean import, and in this case, non-fat company they import as chemical substance. Okay, and because they import, it will be considered an act of using, and then for within Article 126. Okay, so you get it. They import because keywords of this case. Okay, now we move to the second case that's concerned to the utility pattern. Okay, utility pattern of Dong Tan Back. So, what's the act of infringement in this case compared to the pattern? How many criteria we need to consider for utility solution, utility pattern? Yeah, exactly. So, can you compare between the pattern and utility pattern? What's the difference? You see, the utility pattern is more simple. It's more simple than the pattern. Okay. Whether the pattern they need to respond to the novelty. Second, inventive, and the last one, industrial application. Okay. And for utility pattern, first one they need to respond to what criteria? It must be news. Okay. Second, industrial application. So they don't need the inventiveness. Okay. Because inventiveness does let's say that this invention will be created by an expert. They call the people they have knowledge in this domain. Okay. So the second case of Hưng Phú Thành, that we fall in the regulation of utility pattern, or we call utility solution. Okay. So okay, that's correct. Thank you. So when you're doing an exercise, we need to determine which subject matter of the case. Okay, whether it's for within invention or whether it's for to the utility pattern. All right. And then the last one is about the compact, and that's concerned to the industrial design. So can you tell me how to determine an act of infringement of industrial design? Which condition which is the specific thing of industrial design. Okay, how to determine which criteria. For example, the duration of protection is how many years, and how you can calculate to make sure that industrial design still valid. Okay. To determine an IP object, we need to determine the owner hold a valid certification. Okay. So we need to consider the duration of the protection. So can anyone answer me? Industrial design can be protected for how long? Precisely.
Nghĩa là 10
Yeah.
years, 18 years. Yeah.
10 or how many years? Okay, good.
For the industrial design pattern salt has the validity starting from the grant date and expiring at the end of 5 years. After the filing date, it may be renewed for 2 consecutive terms, each of 5 years.
Total?
Yeah.
In total? How many years?
So in total 18.
The first registration is 5,
5 years.
and you can renew for twice.
Yeah.
And that means 5 multiple 3 equal, yeah,
15 years.
15 years. So in order to determine that industrial design application is valid, you need to count from the filing date. Okay? So you need to track when is the filing date, and then you plus 15 years until the date the infringement action happened. Okay, if they still in that protected period, and then we conclude that's an act of infringement. If they already expire, okay, we say no, it's not infringement because that's already expired. Okay, so it's very important to consider this term when we determine an act of infringement. Okay, and that's the same case for the patent. For the patent, how long?
And for the patent is 20 years after the filing.
And the UT patent?
10 years.
10 years. Okay. So when you do complete, okay, 10 years, okay, and this one 20 years, and for industrial design is 15 years. Okay. So when you do an exercise later in final exam, you need to determine step by step, like I showed you before. The first one is about the check method, whether this can be considered like an invention or utility patent. And later we need to use the article 6. Okay. So whether these objects need to register to be considered as a patent or not. Because some subject like trade secret, you don't need to register. So luckily in this case we need to register. And then the last one is about the duration of protection. Okay? Period of protection. We need to say that's still valid. Still valid. So one of the difficult things of this case we need to consider valid patent or valid certification. So for copyright we use the word certification. This one we use the word patent. And then this one we use the word certification. So another way to patent, the change of the vocabulary. Okay? And then we consider the duration of protection. And that's what we need to specify which act, for example, import. And normally for this to decide you will answer using. And then lastly, you need to set the yield without authorization and without paying any remuneration. Conclusion. That's an act on it. Okay. So, last question. The concern to the claim for damages. So, can you compare for 4 cases? Okay. You compare the level of compensation for damages. Can you compare? The value of the money, okay? The level to compensate for the damages compared to the copyright infringement. What is your comment about that? Thank you. So compared to the copyright and compare 3 cases. For the value they can compensate for the infringed party. Do you think that's adequate? Do you think that's fair? Do you think that's okay?
For the all of the case studies in our presentation today, I only see the civil remedies according to Article 202. First, a compelling determinations of infringing acts. Second, a compelling the public apology and rectifications. And for a claiming for payment of damages. And the fifth, a compelling destruction, distribution, or use of non-commercial purpose of goods.
So, what are your comment about this remedy?
So,
Do you think that's appropriate? Do you think that's
well,
do you think that's appropriate? For example, lawyer fees.
I think well, basically all the remedies applying here is kind of fair to both parties, but for stricter purpose, I don't think it's really effect on each case. So yeah.
Okay. Any other comment? Any other comment? Thank you. Would you add something? No? Okay. So, first of all, You don't, right? You have something to say? You have something to say? So, first of all, congratulations on your groups. You have seen that you good prepared, colorful slide, and bring out a paper so I can have some comment here if you want. I don't have a pen to mark on. Again, take a pen. So if you need a mark, you tell me. And then your group, I have seen that you know the problems. You didn't find exactly the key word, but closely. I see the word import. Import. And then in the future, if you have the chance to have the second presentation, I recommend that you present without a paper, because now you depend on the paper and you read it. But maybe next time I expect that you make some small note, and then you can stay in the middle of the screen, and you can use more your body language to communicate with the class, and maybe ask some questions to our audience, because I have seen that our friend is not looking at the presentation. They rather look at the computer, or I don't know, they play video game or do something else. Only me look at you to listen, and I'm not sure that our friend did the same thing. So in order to solve this problem, you need to keep asking the question for our friend. For example, what's the invention, what is the criterion, what is duration of protection, and so on, to keep our friend awake. Okay? So in general, I congratulations. Very good. Okay, so give a bit hand for this group. You have a second group for today?
Yeah.
Yeah, let's go ahead.
yêu cầu quý thầy cô, các em sinh học viên, các em sinh viên và các cá nhân đang có mặt trong khuôn viên trường tạm mọi hoạt động. Đề nghị mọi người đứng dậy, điểm dấu trang phục và hướng về số việc. Tất cả những xưa chào
our presentation is about Mark, and my name is NGUYEN. So let's jump right into the presentation. Okay, and you can see on the board there's 4 members of our group, that Đức and Long and me. So, and they, each member has their own role. And I will talk about the definition specifically in WIPO and VNIP law. And under WIPO is state that a patent is an exclusive right granted for an invention, which is a product or process that provides in general a new way of doing something or offers a new technical solution to a problem. To get a patent, technical information about the invention must be disclosed to the public in a patent application. And under VNIP law, it's way simpler. Is a mark means any sign used to distinguish goods and or services of different organizations or individuals. Okay, so now my friend will continue the presentation.
Good morning, everyone. Now I will present about characteristic of the mark. So, the first one, in Article 74 of the IP Law 2005, regulates that a mark shall be deemed to be distinctive if it consists of one of more easily noticeable and memorable elements, or of many elements forming an easily noticeable and memorable combination, and does not fall into the case stipulated in Clause 2 of this article. And many people make mistake in the mark and the trademark characteristics, so I decided to make a comparison between these. So for the first characteristic, a mark is legally protected by the law, in specific, the IP law, while the trademark is not protected by the law. The second characteristic is the mark has the unique signs underwritten or images, etc. And for the trademark, it does not have typical identifier but recognized in the mind of the customer. And for the final characteristic, the mark has the license, which only lasts for about 10 years, but the owner of the mark can also extend its limit time in consecutive times. And for the trademark, the mark lasts for a long time in an unidentified timeline. Next up is the well-known mark. So for the definition of well-known mark is regulated under Article 1 of Vietnamese IP law, in Clause 20. It regulates that well-known mark means a mark which is widely known by the relevant public throughout Vietnamese territory. And for the condition for evaluating whether a mark is famous or is well-known or not, it will be regulated under Article 75 of this law, and also the Article 23 of the IP Law 2022, amended IP Law 2005. So the content of Article 75 is well-known mark is more widely known by relevant public sectors throughout the territory of Vietnam, and there are eight criteria in order to determine whether mark is famous or not. And now our group will compare between the Vietnamese IP law and the US code.
That's the same problems. We amended 3 times. Okay.
Sorry.
Vietnamese IP law. They amended 2009, 2019, and then
2022.
yeah. So series. Okay. Return.
So now we will compare Article 75 of Vietnamese IP law with the US code. For the first characteristic, under Vietnamese IP law, in order to determine whether a mark is well known or not, we will determine the number of relevant.
The term you use is trademark, it's not mark. You use the word trademark law, okay? A mark is an element of a trademark.
Okay.
So let's go to trademark law.
Yes.
Because the
so-
word mark only appear in the definition, that's it. So the trademark, that's conclude mark.
So the first characteristic is the number of relevant consumers who were aware of the trademark by the purchaser or use the goods or service bearing that such trademark are from advertising. For the US IP law, in order to determine whether trademark is well known or not, it will depend on the duration, extent, and the geographic reach of advertising and publicity of the mark. For the second one, is the territorial area in which the goods or service bearing the mark are circulated, which is if a mark is not well known in Vietnam, but is well known in other places in the world, so this might not be considered as a well-known trademark in Vietnam. And for the US code, it regulates that the amount, volume, and geographic extent of sales of goods or service offered under such trademark will determine whether that mark is famous or not. About the third characteristic, under Vietnamese IP law, it regulates that the turnover of the sales of goods or the provision of services bearing the trademark or the quality of the goods sold or the service provided. And for the US code, it regulates that the extent of actual recognition of the marks will contribute to its well known. And the final characteristic under Vietnamese IP law is the duration of the continuous use of the trademark. And for the US code, this is whether the mark was registered or the principal registered in the United States or not. Next, my friend, we will present about the conditions for the mark's protection.
So about
Okay, let's go for today. Yeah, run out of time.
Keep that for next section, and your group will you modify the word trademark. It's not a mark.
okay,
Because if we keep present the mark as not correct.
because we will have to search and we found that trademark if we talk to UN and mark for
No, mark is a mark.
it's a little bit confused. So
Yeah, exactly. Because we don't have time to study the theory of this. So your group will modify by adding a trade.
so we will do that.
Exactly, in front of the mark, and then we keep that for the next section. Yeah. Thank you. Yeah. So we have the definition of a trademark already, and also your group also very well done. You present about the famous trademark. That's on the Article 75, or we call the well-known trademark. Okay. So one of the trademark law. You need to read more the document on the trademark law, okay? So I will give you something about the trademark law. Trademark does mean it's a product, yeah, from product or service from the same product. For example, TL here is called Thiên Long, okay? This is a mark. The mark does mean the color, set, rectangular, circle, straight, everything. Distinguish a product or service. Okay, so that means the trademark. Trademark does mean the mark you in commerce. All right, mark you in commerce. That means a trademark. Okay, in your group get it? Okay, so next term you have this group, okay, and then we keep presenting other groups, and if we don't have time, we will keep that for the one online lesson. Okay? So don't worry if your group cannot be presented, okay? We will have enormous of time. Okay. Okay. Thank you again for the.
Đấy.